Yep,
Yes?
I can hear you.
Okay. Um, I want to start out with obviously a little bit of talking about the market. And so I'm going to share my screen here. And can everybody see that okay? Yes?
Yes.
Yes,
Okay, so first of all, the market is continuing. I do this every Tuesday because I don't want the weekend to skew the numbers, but we're continuing in a pattern that where we see more new listings, and we had a little bit of a sales increase this week, but new listings are the same as a little bit less than sold listings in Collier and Southwest Florida, but more in Lee. Notice the number of pendings, which is our forward look for the next 45 to 60 days, is again balancing pretty well with the number of new listings coming in. But the elephant in the room is the number of price reductions that we're seeing every week. And we talk about it. I think I'm showing you how to go into Matrix and look at the individual reductions and how much they were and what neighborhood they're in. But the market is continuing to operate. And where we're seeing the shift is in more choices for buyers and definitely moderating prices for sellers. So I still continue to recommend you jump on the James Shaw call every morning for 10 or 15 minutes to listen to what some of the great minds around the country are talking about in the way of issues they're having with their sellers. And buyers are becoming more emboldened. They're seeing more choices. They're tending to be a little more aggressive with their pricing. So, it's unlikely that a seller who's sitting well over market and hasn't had a showing in a couple of weeks and says, well, I still think my place is worthwhile. It's unlikely that that's true. And the better you can educate your seller, I would at least update them once a week with the activity on their listing. I would definitely set up an MLS search in the neighborhood or radius around that listing to see what's happening with other listings, especially other similar listings. And then I would make sure I got to the seller every week and said, look, here's what's happening. Here's what's come on the market. Here's what's reduced in price. And for the seller that says, I don't care, I still think my place has green granite and I think it's worth more than all these other places. Then I think you have to go, as Denny Grimes says, you have to go to the pain. So, well, what's your, go to motivation. Well, Mr. and Mrs. Seller, what is it that you want to do when you've sold this residence? If they say, well, we want to go over to the XYZ community and get something a little smaller, the kids are gone, or we want to do, you generally, people don't sell just for the joy of selling. They're selling because they believe the market is somewhat near the top and that they want to be able to go somewhere else with the proceeds that they're going to get from their sale. So I think it's important for you to drill down early on and find out what the seller's motivation is. I want to move here. I want to do this. I want to buy that. I want to travel. Whatever the motivation is, the market that you sell in is the market that you buy in. So, obviously everybody says, I know a lot about real estate. I always like to buy low and sell high. Well, that's great, except that means two different markets. There's no indication from any of the real estate experts, Lawrence Yun from NAR, the Florida Realtors, Brad O'Connor. There's no indication from any of these people that we're in a bubble and there's going to be some, huge drop in prices. Obviously, demand patterns have changed because of the interest rates, although they trickled down under 5 this week, and that probably will stay. Everybody's saying they're going to stay in the 5.5 range. They're not going to go way up, but they're still double what they were a year ago. So that's obviously affecting the demand patterns. But the main key here is if we're taking 711 new listings and adding 850 price reductions, that's 1,568 new opportunities in the last 7 days in the Southwest Florida market. So it's important that you pass this information on to your sellers. It's also important that you continue to inform them about what's going on around them in the market. And, some of the script classes that I've sat in on say, you need to be ahead of the market. Well, I think that's true, that you need to be ahead of the market when establishing prices for new listings, because you can't ignore what else is going on in the market. That doesn't mean, unless there's extreme motivation, that you have to automatically put your new listing out lower than all the other listings. I think it's features and benefits, and it's certainly things, trying to do your CMA to compare features and try to get it as priced closely as possible, given what's going on in the market. So again, we're transitioning from what you can call a luck or opportunity-based market to a skill-based market. And I think this plays right into our hands because we have good market data. We can talk to the sellers about what's going on in their neighborhood and what's going on in the overall market. And we can get them to make good decisions to put their property in a good place to sell, understanding that if they're going to look somewhere else, the same thing's happening in these other markets. Although everything's neighborhood specific, chances are this kind of thing is happening, in all of the major markets in Southwest Florida. Okay, so keep that in mind. And I think one of the things I hear in Denny Grimes' script class, which I encourage you every Friday afternoon from 1 to 2, he gets 100 people from around the country on, and they actually do some script and role playing addressing today's concerns. Sellers that don't want to sell, buyers that want to buy lower than the market, and a lot of good discussions about pricing, about price reductions. So if you have an hour Friday afternoon, grab you a coffee and jump on that call. It's a very good call. So the 2 calls that I'm recommending highly every week are the James Shaw call in the morning while you're having your morning coffee or milkshake or whatever you have. And in the afternoon on Friday, when you're just winding down for the weekend, great place to, you can participate. You don't have to participate, but you're listening to some great script and role playing. Probably Denny Grimes is the master at, probably one of the better script and role play professionals that's ever come along to real estate. And he's very active in these classes, and he encourages people to get into role plays. And then he kind of chimes in with, his idea of what questions to ask. And he's very question based. He doesn't like to see you make statements. He likes to see you ask questions. So if you get into that habit and take a look at what some of the techniques he's using, I think you'll be far better off. Okay, so I'm going to stop the share here. And I want to go over to, MLS here. So let me go here. Let me go share the screen and MLS. Okay, so we're back to our MLS screen, and we know that we've talked about this Market Watch widget that's on everybody's screen, and we've talked about how you can take a look at what's going on in the overall market. And the other thing, not to ignore, but the back on market number has gone down a great deal. These numbers were overall for 7 days in the 150 to 200 market. Look at, they're now down to 34. So what we're seeing is mainly new listings, pendings, and price decreases. Right? And that's the overall market. Now you can customize, you can reset any market. This is the overall market here. Okay, so back on market 180, new listings 740, exceeding, solds, pendings up a little bit again, and look at the price decreases 817. So you can click on any one of these and take a look at them to see what's going on, to see what this particular screen will give you the amount of changes. Okay. Here's one down 59%. That's interesting. Anyhow, most of them are 4 or 5%. Here's a 7, that sort of thing. So I don't think we have indication that the market is crashing, but the market is actually moderating. Let's go back here. Can everybody see this, by the way? Am I sharing the right screen?
Yes.
Yeah, okay, good. All right, so I'm getting ready to do the numbers for July over July, but I wanted to show you some interesting early stats here. So hopefully if this will work, which it did, okay, good. So we can let's look at Collier. And this again is InfoSparks, which is available from the main screen of your MLS. If it's not a widget, it's a link in the quick links section. But let's just take a look at what's happening now. Look at median prices. We're starting to see the effects of the market, all right? Now, median prices are up 10% over a year ago. Okay, but look at what's happening to the trend over the last 3 months. May peaked at 635, down to 620, and now down to 550. So we're starting to see median prices come down as a result of more choices on the market and more deals happening and more price reductions. Let's take a look at sales, total sales. Look at total sales down 46% over last July. So it looks like they might have been peaking around April of last year, and they've been kind of steadily trending down with a couple of bumps to where we're not selling anywhere near the number of units we did a year ago. And we can easily, as you know, add Lee into this mix, just to show what the various county differences are. So you can see that sales are down 27% year over year in Lee and 46% year over year in Collier. And if we go back to our median prices, you'll again see that the market, the shift in the market is starting to take effect and be real. We've talked about it a little bit. We haven't seen it in the year over year numbers. But look at prices in Lee. They're still up over last year, but you see the last 3 months they've been trending down. Okay. So the affordability factor, although influenced by the increased cost of financing, the affordability factor is starting to show. And if we go and look real quickly at new listings, you can see that those are coming down. In Lee County, down about flat from last year, but look at the last 3 or 4 months. Look at the trend. In Collier County, down 18% over last July. So even though we're seeing more listings come on the market than each week than that are selling, we're still seeing the trend is down in new listings. Now let's take a look at this. This is our first season since 2019 where we're seeing the effect of seasonality. If I go back to 2019, let's see. So you can see in 2019, we started to see, now again, this is before COVID, but we started to see our normal pattern in the summer of listings going down and then going up a little bit in September and October. So we started to see the seasonality curve. Notice in, other than April, which was the month of COVID, March and April, notice that listings didn't tend to go down too much for seasonality, except possibly a little bit of a blip here in the end of 2020. So it's interesting to see what's happening not only year over year. Obviously, we know that 2021 was a year that like no other. But it's interesting to see, look at what's happening in trends. So as you're talking to your sellers, new listings coming on the market are definitely trending down. And watch what's happened to days on market. Let's do average days on market. MLS is grinding today. So days on market should start to invert here because last May of 2021, the number of days on market went from 57 to like 25. And now we should start to see the numbers come back up. We're seeing that days on market down, still low, but not trending down as much as they were, a year ago. Not sure why we're not getting any numbers here, but if we can quick grab, there's month's supply of inventory. So you can see that month's supply of inventory, although it's not jumping up, it's up to 2.5 in Collier County versus, back in January and December and January where we had 1.4 in December. That was kind of the low point there. See, so even we're not jumping up into a buyer's market or even a balanced market, we're starting to trend up in terms of supply over last year, which is an indication that that there's more activity coming on the market in terms of a combination of listings and price increases. All right, so those are the early peak. I usually don't pull these numbers till the 9th or 10th because there's still data coming in from last month, but I just wanted you to see some of the key indicators. There's days on market. You see where it's trending back, starting to trend back up a little bit. From its low, we're now starting to see month after month of increased days on market. So we're definitely in a shift, not necessarily a radical shift, but a shift in supply, opportunities for buyers, price reductions, days on market. All these things are indicating, and month supply are all indicating that the market is changing. So stay close to these numbers. They're on the facing page of your MLS every day. So, you should be able to see these things and you can hone down, remember, you can hone down into a particular neighborhood. If you want to look at a development called Pelican Bay, just put it in there. Now you'll start to see what's happening in Pelican Bay. Again, look at the days on market. Even though it's below last year, everything's trending up in days on market, trending up a little bit, not much in Pelican Bay, but a little bit up. And then your median price, your new listings, trending down a little bit. But this is a really nice little tool that you can spend a few minutes with a cup of coffee and zero in on a neighborhood or on what's going on in the overall market. I wonder why he's taking so long. Still going to add Pelican Bay in here. Now we can start to see Pelican Bay, which had no listings, still has no listings, 12 versus 25 last month. So there's not a lot of new activity going on in Pelican Bay, but let's take a look at median prices. See, median prices, even on a small sample, are still going up a little bit, but the trend prior to that was down. Now we had a little blurb up in July. Remember, on small numbers, obviously you see a lot more fluctuation in Pelican Bay than you do in Lee County and Collier County. So when you get into smaller numbers, your median calculations and all are more, they have a tendency to float around a little bit more. Okay, any questions on that? Anybody want to comment on what they're seeing in the market? Mark, how about you?
Sorry, Jeff. Yeah, I was going to ask you kind of a tangent to this. What kind of information can we pull from showing time?
You can pull showing time info from the stats on InfoSparks, which,
Like like you mentioned Pelican Bay. So if I had a listing or I was about to get a listing and I wanted to know information that came from showing time, what would it tell me?
well, you can get showing time information for your neighborhood from your actual showing time login. But there's two stats here that InfoSparks does work with. And one's called shows to pending, and the other one's called shows per listing. So you can start to see in Pelican Bay, the showings to pendings is actually, obviously with a market that's got not that many, it fluctuates a little bit more. But look at all of a sudden the showings per pending are kind of trending down on average. And you can look at the showings per listing. Okay, so the number of showings per listing is going down also. Probably seasonality, Mark, as much as anything else.
That makes sense. You know, when we were looking at the inventory numbers and the days on market and the month supply, we could see that kind of do a zigzag as we get closer to October.
Right.
And then November and December. I wouldn't expect it to be a straight line. I think it's probably going to bounce around a bit. You probably see an increase in inventory and maybe more showings per listing and more showings depending, all those
And
numbers.
more open houses, more efforts to get the listing out there and get traffic.
Yeah.
So I think, you know, if we're truly returning to our seasonality, we see activity drop off this time of year, and starting in October and fully into November, that's when people that may have been holding off, like, hey, you know, I see that there's a lot of price decreases. I see a lot of new listings coming on. Maybe I'm going to wait until the season starts. And the season typically starts here. People come down October, November, and December. And then, you know, obviously January is the start of peak season. So if we're in our seasonality pattern, we're going to see listings start to uptick starting probably in September, October, and November, with people saying, okay, the market is what it is, but now's a good time because I'll get more traffic and I've got a better chance of getting a great offer if there's more traffic and more people are seeing my listing. So I expect you're right. You'll see an uptick in listings there. So, okay, well, I'll have the graphics, the market graphics and the trends for tomorrow's meeting in Naples and Wednesday's meeting in Marco. So I'll have those to share with you, but I just wanted to give you an early snapshot. It's definitely returning to a seasonal pattern for the first time since 2019. And, you know, to a certain extent, the market's taken a little bit of a break, because remember, when people were down here in 2020 and 2021, they couldn't go home. Many of the states were still shut down. Canada, the border was still shut down. And, you know, the other variable that we're seeing, according to the airport and visitor stats, we're now starting to see an uptick in foreign visitors. And that's going to change the market around quite a bit also. So we're seeing more tourism from overseas now. They've opened up a little bit more, and I think overall people feel like it's a little safer to travel than it has been. So I think the international market has been very quiet for the past couple of years with COVID. So we'll start to see some uptick. Canadian markets open again. I think you'll see a lot more Canadians coming in the fall and spring. So the demand patterns may react to that. But still, with only 2.5 months of inventory, you know, we just don't see the conditions being right for, you know, a big downturn in pricing. So, but we'll have to see. I mean, we're seeing what's probably a little bit of a healthy shift in that prices are moderating, new listings are coming back, And people that were shooting for the moon are starting to say, wait a minute, if I want to sell, I'm going to have to get back to where the market is once we've seen more people in each of the neighborhoods starting to list their property. So, okay, I'm going to shift gears back to contracts here. And I have I'm going to, my next project is I'm going to do the 10 most significant contract hacks. But today I want to dwell on one that I've seen quite a bit of recently. And I'm going to go ahead and I want to go ahead and share this screen here and talk to you a little bit about something that I see that I think is important to review. It has to do with the financing contingency. Can everybody see that okay? Yes?
It's a little bit small.
All right, I make it bigger. For you, Kristen? I make
Oh,
it.
thanks, Jeff.
How about that? That bigger?
Yeah.
Okay. So let's go to the financing contingency paragraph here. Now, remember, when you're working with a customer and they've decided to use financing, okay, let's just take the very simple one, conventional, all right? Now, if you notice on line 61, there's a question here. Initial or fixed rate of interest not exceeding % per year. And I'm seeing more and more contracts where that's blank or market, MKT. So I have a question for you. How are you protecting your customer who's looking to use financing, but who isn't intending to take on a mortgage that's beyond their expectations? So if you put blank there and the lender comes back and says, okay, Mr. Jones, we'll be glad to loan you the money at 8.5%. Your credit's not great, and this is a second home for you. And oh, by the way, second homes are not getting first home rates anymore. They're getting higher rates, 7s, 6s, 7s, and that's due to Fannie and Freddie's guidelines have changed a little bit for second homes. So if I don't put a number in there and the lender comes back to me with 8.5 or something crazy, and I go, I really don't want a mortgage for 8.5, but your credit score is good. Your debt to equity, your debt to income ratio is okay, even at that higher rate. Can I get out of the mortgage with a financing contingency? Will I get a letter from the lender saying, Mr. Jones doesn't qualify? No, but instead of protecting the customer by saying, look, if it goes over 7%, I know it's a second home. If it goes over 7% and the best loan I can get is 8, I don't want the loan. I want to be able to be protected by my financing contingency. So you, as the real estate professional, want to have that conversation with them. If you leave that blank, you're basically leaving a pretty big hole in the financing contingency, because no matter what rate the customer is quoted by the mortgage lender, if I qualify for it and I don't have any debt to income ratio problems or any credit score problems, that's the loan I'm going to get. And if I don't want that loan, what's at risk? My deposit. Okay. So I think this is a hack that, we talked a little bit about it. FAR bar says if left blank, it's the market rate or prevailing rate based on the customer's credit score. Well, again, that's great if you leave that blank in FAR bar and it's the prevailing rate based upon the customer's credit worthiness or credit score. It could still be high, because I could still have a high credit score but not qualify for a loan program for a second home that I'm going to get the money less than 7.5%. So I'm just saying, Broker Jeff is just saying, this is a possibility that this could be not a good thing for your customer. So I suggest you have the discussion and you always put something in there. If you put MKT in there or leave it blank, your customer's a little bit vulnerable. And in FARBAR, I see MKT all the time. I don't know what that means. If my credit score is 650 and Mark's credit score is 840, he's going to get a different rate than I am. And if I don't put anything in there, I may not like the rate I get, but I may be able to qualify for it. I may not be able to get a letter from my lender saying I don't qualify. Now in FARBAR, it's a little easier because all you're really basically saying is I can't get the loan, or I can't meet the terms of that loan, and you could do that in an email. So it's a little bit easier to get out of FARBAR. Note in NABOR, the way to get out of this is an equal credit opportunity statement of adverse credit issued by a creditor or lender confirming that mortgage financing on the terms set forth in this contract was denied on the grounds that either the property is unacceptable to the creditor lender or the buyer financially failed to qualify for said terms. Now that caveat number 2 that says, I made good faith efforts and I never got anything back from my lender. I don't know that that's as easy to prove as you think. So anyhow, that's my observation on the financing and the interest rates. Now, back when they were 2 and 3, you could put 3 in there and be fine. Now they've just dropped maybe a little bit below 5, but right at 5. And if you put 6 in there, you're probably giving your customer a range that they can live with. But if you put nothing in there and it's a second home based on the credit and everything, it could be much higher than the buyer's expecting. So how about any comments on that line of reasoning and that discussion? Anybody?
No, I think that makes a lot of sense. Is there a certain range that as a listing agent that you would be looking to avoid, or?
Well, if your buyer has done their homework, they've talked to their lender, and their lender has said, based on the pre-approval that I've done here, it's looking like you could get, a nice deal at 6.2 or 5.8 or 5.5. So in the pre-approval process, the lender should be able to opine on what the approximate rate is. Now, now you're talking about getting a rate lock that could protect you from fluctuations. But I mean, the lender really, that discussion really should have been had between the customer and the lender, because if you're getting ready to write an offer, you need a pre-approval, and usually that pre-approval is for a certain amount, and it's based on a rate discussion that they've had with their lender, and the lender says, okay, Mr. Jones, we can qualify for you up to 650,000. And your credit score qualifies you for our program A, which is 5.1%. So now if I'm having this discussion and I got that information from my customer and I put 5.5 or 6 in there, then I think I've protected my customer from all of a sudden, the Fed raises everything another 3/4 of a point, that the long-term financing numbers change and all of a sudden it's 5.9 or 6.2. That's not what I signed up for. That changes my affordability factor. And I want to protect my customer from a fluctuation in the market if they're not able to get a rate lock or pay for a rate lock. Interesting. So that's
my question really is like, if you flip it to, if you're representing the seller, is there a range that you would kind of look to or avoid to protect your seller?
Well, again, there you can probably only look at prevailing rates for 30-year fixed mortgages, and those numbers get published every week. And if they put 4.5 in there, I would say as a seller, I mean, you're not going to be able to get a loan for that. All you're doing is setting me up to be able to walk away.
Okay, that makes sense.
I mean, if you see 5, 6, I've seen 6.5, I've seen a couple at 7, then you've set the buyer's expectations and also the seller that, hey, I'm going to submit this pre-approval letter with my loan, and my pre-approval and or my rate lock is based on a certain status of the market at that time. So
Okay,
That's-
thanks, Jeff.
I think it's important that you look at that, and I see, because I do the compliance, I'm seeing more and more blanks in there, more and more MKT. MKT doesn't mean anything because the market rate for me and the market rate for someone with a much different credit score and a much different debt to income ratio is different. So MKT doesn't really protect your customer very well. So just saying. So let's go back to something that I did last week where I was looking at the lender's questions. Let's see, I need to go back here to here. I need to go over to here. And I'll share. Whoops, wrong button.
Where is that?
That is a shot from Majorca, Spain.
That looks nice.
From a what am I doing here? Here we go. Meeting controls. Stop share. Share screen. All right, I got this. Okay, I'm gonna make that a little bigger. Let's make it a handy. Okay. I don't know how many of you were here last week. We started going through these. These are questions that I put together when we were doing the ask the attorney forum. And we were initially concerned, maybe, what if nobody asked a question, or what if we got too few questions? But now when we have these, we don't use this list anymore, we get great questions from the audience. But at any rate, we got down to probably what is a fixture and what personal property in a sales contract, and how to determine what doesn't and does not convey to the buyer. And again, a fixture, here's the perfect example. Is a Ring doorbell a fixture, or is it personal property? The answer is most Ring doorbells are screwed into the wall, right? They're not just hanging there, and they're not on a bracket. Usually the whole assembly is screwed into the wall. So that makes it a fixture. So if I'm the buyer and I see a Ring doorbell on there and I put it on there as a fixture, and I go for my walkthrough and there's no Ring doorbell there, and this happens a lot, it's like, wait a minute, hold it, that was a fixture and you took it down. It's not like it was a TV and it was mounted on a bracket. It was a screwed into the whole mechanism was attached to the wall, making it a fixture. So you have to be careful with that. But I continue to go back to my mantra that you have to have some form of an agreed upon written or photo inventory that allows you to verify what's conveying at the walkthrough. And if there's a problem at the walkthrough, then you can resolve it by a credit or by having the stuff come back or whatever the resolution is. But the minute you go past that point, I had a seller call me last week and say, my name's Joe Schmo, and I closed, last fall, and I just want to let you know that your agent told the pool man that he could take whatever he wanted. And there was a lot of stuff missing when I came in, and I want some money. And I'm like, well, Mr. Schmo, did you have anything in writing as to what was? No, it was the whole thing. The contract said everything. So what did it say? It said everything, furnished. I said, well, did you have a list of anything? Did you make a list? No, I didn't need a list. I had pictures from when I saw it. Okay. And did you do a walkthrough inspection? No, my agent did the walkthrough inspection. But there's a lot of, when I got there, there's a bunch of stuff missing. I had to go out and buy a couple of TVs. I had to buy kitchen stuff. I had to buy bedroom furniture. And I want your agent to pay me $2,500. What are you going to do about it? And I said, well, Mr. Schmo, unfortunately, you missed a number of opportunities to protect yourself from this kind of thing happening. And I will be willing to guarantee that our agent didn't tell the pool man that he could take what wasn't his. That's not something that an agent, I already had a conversation, as this guy had already made an objection, earlier. But the point is that there was nothing, and the agent for the buyer walked through, noticed that there was a bunch of stuff missing, didn't say anything, didn't call the buyer and say, hey, we have a problem here, just signed off on it and went on their way. Maybe he has some recourse against his agent for doing the walkthrough on his behalf and not noting any of this stuff. But does he have recourse against our seller or us? Because there was nothing in writing, nothing agreed on. But this is the kind of thing that happens, and I still think that even though it's a drag, if you're the buyer's agent and the seller didn't give you an inventory or anything to work with, I know it's a drag to go take the inventory or photograph the inventory and have everybody sign off on it, but it's your only proof. Now, it's unlikely that buyer is going to do business with that realtor ever again. So was it worth it? Not taking an inventory, not having anything signed off? Probably not, because, as we know, if you put people in your database and you do a good job for them, they make a real estate move usually every 3 to 5 years. So if, your job is to do a great job and then stay in touch with them. And then if they decide they want to move to another place or buy another home, you're top of mind and they're going to call you back. But they won't call you back if they feel like they were not well served. So there you go. That's number 11 there. How do as-is contracts differ from standard purchase and sale agreements? Yeah, like about 180 degrees. An as-is contract is, and from these classes that Broker Jeff is absolutely not a fan of as-is contracts, although we know in Lee County, probably better than 90% of all the contracts written are as is except as is, but you got to make these repairs. You got to give us a credit. You got to lower your price. Well, is that what it says in the contract? No. So as is contracts came into vogue starting around 2007 when there was the distress period hit the market. Lenders and investors became owners of properties that they knew nothing about. And they said, you take it as is or don't take it. And that was where these contracts started. And then they morphed into a as is but. And it was a way of the buyer getting a due diligence period. And if for some reason they didn't like it, or for more likely the seller said, I'm not giving you any money. We bid this contract based on as is. And now you're asking me to fix this or that or a credit or lowering my price. And if I'm not going to do that, the buyer can walk away. However, if you look at the standard purchase and sale agreements, their design is to keep deals together. There's not a lot of open doors for a buyer to go flying out of because they change their mind. But generally in as-is contracts, buyers don't change their mind. They ask for things that are not provided for in the contract. And again, if you don't put language into your as-is contract that deals with open permits, liens, code violations, and you don't put that into your other terms and conditions, you basically can inherit a property with all kinds of problems. And the seller is like, I didn't know anything about those things. They're yours now. So again, the standard purchase and sale agreements provide for repairs. They provide for radon and mold in the NABOR contract. They provide for open and expired permits, and they provide for protection for the buyer when during your due diligence period, you discover things that weren't visible to the naked eye or weren't visible when you did your showings. So there's a huge difference between these two types of contracts. And what is the COVID-19 metamorphosis? Anyhow, it morphs into another form, just like the as-is contract is morphed into another form, and now it's as is except. And again, I see them all the time. Okay, I wrote as is, we agreed on a price, and now I want you to fix these 10 things. And the other thing you have to be very careful of in an as-is contract if you present an as-is contract, it's accepted, and you do your inspection, and there are items that you want the seller to look at. Because remember, there's no defect versus cosmetic in an as-is contract. It says, I want you to repair this. And you say, I want you to repair these 5 things, and the seller signs off. Does the seller have to use a licensed contractor? Nope. Does the seller have to provide you any kind of receipts? Nope. Can the seller hire his famous handyman, Freddie, to fix the air conditioner? Yep. So you have to be very careful when you're asking for changes or repairs in an as-is contract. It might be worth your while, if they're significant, to have your friendly local attorney write an amendment that says, hey, we're asking you to fix these things. We're asking you to use licensed contractors. We're asking you to provide receipts from those contractors. And that's what we're asking you to do. And if the seller agrees to that during the due diligence period, then you got something. But other than that, you really don't have much. I guess my friend that I used to play a lot of golf with, he called it a Georgia guarantee. So what's that? He said, if it breaks in half, you own both pieces. Anyhow, that's what you get on an as-is contract when you ask for repairs and you're not specific about what you can do. Flip over to the standard purchase and sale agreement that does require that licensed contractors be used. In the FAR it does require receipts to be given to the buyer at closing, and it protects the buyer from repairs that aren't done properly, or repairs that are not done by people that know what they're doing. So maybe you get a Band-Aid that 3 months after you move in, there's a breakage or there's something crazy that goes on because you didn't get a good repair person in there. So I don't know. Would anybody like to comment on that, Mark? Are you what are your thoughts on as is versus regular contracts?
Probably just, you have to make a decision as to what the specific needs are of the customer, and are they, willing to roll the dice, and can they get the inspections done in the time frame that the seller wants them done? So there's a lot of variables in it.
And I think that on the flip side of that is, if the buyer truly finds a defective item, like the air conditioner is supposed to be cooling to 16 degrees and it's cooling to 12, that's a defective item. And if I ask the seller to repair it or have it looked at, and the seller says, I thought we bargained for as is, Mark, I'm not doing any of that. Now you are the seller and the seller's agent. Now you know of a defect, correct?
Right.
So do you have to disclose that to the next buyer?
Yes.
Yes. So there's kind of a little bit of a double-edged sword in as-is contracts, where you discover a truly defective item that's not readily observable. And now you're kind of back to Johnson v. Davis, where you have to disclose it. So there you go. What is an addendum and what is an amendment, and when to use each? In the FAR contract, there are no amendments, so you don't have to worry. You always use an addendum. And I've asked, legal resources at Florida Realtors about that, and they just kind of shrug their shoulders and they go, well, that's the Florida Realtor Florida Bar Committee that says they don't want people to get confused and write the wrong one. In the NABOR contract, it very definitely breaks down into addenda and amendments. And we always encourage you, after the contract is ratified, there are no more addendums. An addendum is added on to an existing contract, and when ratified, becomes part of the original contract. An amendment is a change to the original contract, which could have included the regular contract and addenda. So I always recommend you amend a contract that is already ratified, and use in the NABOR contract, use the amendment forms to do that, whether it's a listing agreement or a sales contract. You want to amend it after it's ratified. When is the HOA disclosure required, and what happens if not supplied with the contract? Also, what is the effect on the contract if the information supplied is incorrect? The HOA disclosure is based on the HOA law, different than the condo law, right? And the HOA disclosure form, which should never be used for a condo, just HOAs. And how do I know it's a condo? Generally, after the early 80s, the word condominium is in the legal description of a condo. Sometimes in the legal description for a homeowners association, there's the letters HO, but generally the word condominium will absolutely not be there. So if you have a homeowners association, your best bet is to get the exact information from your seller as to what their last bill was and what the exact name of the homeowners association is. And that usually comes on the bill that the seller gets. So the best bet is to get that bill and use that as the basis for filling out the HOA disclosure. So what is the effect on the contract if the information supplied is incorrect? Okay, so wasn't too long ago, we had an $800,000 or $900,000 sale in a community, and it was discovered by the buyer who'd never been to Florida that the property was only a few feet above flood level. Well, that's where we are in Florida. There's not a lot of things that are way above flood level till you go north and get up in the middle of the state. So the buyer got cold feet and took the contract to his attorney. And it turned out that this community was built in 9 phases. And they had 9 homeowner associations for each phase. And then a few years later, they decided they would consolidate all of those 9 homeowner associations into one. So the current form of the HOA disclosure needed to be the consolidated HOA. Instead, the HOA disclosure that was provided said HOA number 9. The attorney looked at that and said to the buyer, "You're out." Absolute 100%. If the information on that HOA disclosure is out of date or incorrect, the buyer has an absolute right to cancel with no discussion. And so obviously our agent wasn't happy about that when they lost the commission on an $850,000 sale because the information on the HOA disclosure wasn't accurate. So obviously, Broker Jeff has all kinds of war stories to try to convince you that you got to get this information right, and you should get it from the seller or the actual management company that manages the HOA. And if you can't do that, don't go to the MLS and look at what's on a neighboring property and copy all that information down and expect that you're going to always be right, because budgets get updated every year, and oftentimes agents don't go back in and give you the right information. But once you put that on a piece of paper and have it signed by the buyer and seller, it becomes binding. And if it's not correct, the buyer has the absolute right to walk away from your contract. So very important to get that right, and very important to have the information be accurate. I'm told that there are cases where the quarterly or monthly assessment was off by $3 or $4, and has one been off by $3,000 or $4,000. It was not sufficient, and the buyer walked away. So be careful with that. Also, remember that if the HOA disclosure is provided timely with the contract signed by the buyer, within, should be at the time of the contract, but maybe within 24 hours, then the buyer does not have the right to ask for homeowner documents. However, if you're working with a buyer and the listing agent is not necessarily responsive and doesn't upload the HOA disclosure and doesn't provide you with one after a couple of days into the contract, you have a get out of jail free card. You can trigger a 3-day right of review of homeowner docs at any time, including the day of closing. So you can say, well, I really have changed my mind on this. You never sent me the HOA disclosure, And I'm requesting the HOA docs with a 3-day right of rescission. And, I need them right away. And by the way, I'm canceling because I haven't received the docs. So therefore, you got to be very careful that these statutes have some thorns in them, and you don't want to be at the expense of your buyer or seller, a victim of not following the guidelines for the HOA disclosure. I think we will see some revisions. There were already a couple of condominium laws changed at the May legislative session to address structural review and deferred maintenance. So I think you'll start to see maybe the same thing spill over into HOAs that have structural reviews, and normally an HOA isn't involved in a tower, but it could be involved in a couple of story building project with 3 or 4 units in it, coach homes or whatever. And if there's deferred maintenance in the community on the community financial statement, that could be a problem getting a loan from Fannie and Freddie, or I think it's going to be a problem that's defined in the statutes as these things get updated to say that you can't have deferred maintenance. Deferred maintenance means you're scheduled to do it and you didn't have the money to do it. And that was the problem with the famous collapsed building over in Surfside in Miami. They had years of deferred maintenance, millions of dollars, and the residents had turned down at least 6 or 7 special assessment requests. So no, we're not going to do that. Well, eventually it caught up, and unfortunately 100 people lost their lives. So definitely there's going to be some reaction to this in the legislature and in the statutes, and it's definitely going to be coming along. So there you go. When is a condo disclosure required? Also, how do you determine whether a residence is located in an HOA or condo association? Okay, as previously mentioned, the word condominium is in the legal description for a condominium project. It will say the word condominium. It won't say condo or CO, it'll say condominium. So if you see that in the legal description, please do not pull out your HOA disclosure form and fill it out, because the other side says, what are the quarterly payments? That's not, we now have it in red on the HOA disclosure form. It says not to be used for a condominium. Now, how many people read the red that didn't read the bold, that didn't read the instructions before? I don't know, but we still see an awful lot of people supplying HOA disclosures for condominiums. And what's the condominium statute say? Condominium statute says you got to get 7 documents to the buyer. Once those 7 documents are all received, that's day 0. The buyer now has 3 business days to rescind. And if they don't get all of the documents, or they don't get all the correct documents, they get the budget instead of the financial statement. They don't get the current version of the condo, the Florida condominium law brochure. That doesn't constitute delivery, and the buyer can then get out on the condo rescission really at any time. So be careful with that. Always make sure that if the word condominium is in the legal description for the property, that we make sure we get all those condominium documents. And the reason I mentioned that condominium governance form, which is a form that is provided by by Florida, it was revised. See if I can do anything real quick here. It was revised for 21 and 22, and a new brochure was issued. And I'm told that if you don't have that form in its correct form, that you can get in a situation where you haven't supplied all the condo docs. And that's embarrassing, because now you could have a situation where the proper documents weren't given, And let me just see if I can find this real quick for you while I'm at it here. Quick links, labor contracts. There we go. Oops. Okay, do you see this on the form, everybody? Kristen, Mark, you see
Yes.
it? Okay, you see
Yes.
down at the bottom where it says revised for 2021 and 2022?
Yes.
Okay, there's an older version of that. And I'm told by the attorneys that if you were to supply, it's at the bottom of every page you can see. If you were to supply the older one, you wouldn't be supplying all of the condo docs to the buyer, and you could theoretically lose out on a condo review. So just saying, I guess they're getting pretty nasty about it on some of these deals. And so therefore it's important, I think, that you keep that in mind. The current one, I just got that out of the NABOR library. I'm going to hope that it's sitting in our library in DocuSign. I think it is, but I'm going to double check it now that I brought it up. So got a couple more minutes here. So really
Jeff,
understanding.
I just want to add one more thing. It's as a listing agent, I can require that the condominium governance form be, how shall I say, provided to the buyer, or do I need to have them sign it or initial it?
Yeah, I think that was something that we discovered in the crazy days of multiple offers. If you accepted a contract that had better terms than another, but there was a 3-day rescission built in for the condominium, that you were basically giving the buyer a get out of jail free card, because the buyer has the absolute right under that 3-day review to rescind for any or no reason. So what really sharp listing agents like Mark did was say, okay, I want you to sign that form and submit it with the contract that you've reviewed the documents and that you will not use the condo 3-day rescission to get out of this contract. And that was, I thought that was very sharp. I think, Mark, you were the first one that mentioned it in our classes there. But, basically you just closed it, what really is a pretty much of an open door.
Yeah, I think the thing I'm talking about is the condominium governance form. And, within MLS, we're allowed 10 attachments. So I suppose you could combine a number of documents in one PDF and upload it to Matrix. But if you're doing individual forms, you kind of run out of space by the time you upload all the various things in the supplements. So you could put it in the additional remarks that the buyer must initial that they've received the condominium governance form dated XYZ. Otherwise, you have to email it to every agent who makes an offer. Is that right?
Yeah, I agree. I think it might even be easier now because the pace of writing contracts and things has slowed down quite a bit. So now we're more likely to be able to have that requirement that, hey, I want your buyer to review these and sign the release as part of the contract submittals. So that makes sense. Any other questions? I mean, really, it's very important. Again, we're going back to a skills-based market. So sloppy contracts and contracts with holes in them that could expose your buyer or seller to lose a contract are gonna sting a little bit. And that's why we're doing this. That's why broker Jeff flaps his gums every Monday at 1:30. You know,
Well,
I'm really trying to make
and
sure
consistent with that is if you're representing a seller
right.
and you don't cross every T and dot every I, then they may accept one offer. And if that buyer didn't sign the condominium documents receipt or get all the documents, and they walked away and the seller lost another opportunity to sell it to somebody else, or they went ahead based on the offer that they thought was solid and made an offer to buy something else, you could start a train wreck there.
Yep.
And at the same time, if you're representing a buyer, when you don't provide all those documents to them, like you said before, you're giving them the get out of jail free card. They could walk away from the transaction at any point until that clock starts ticking. And you're not going to get a commission, and they may go out and buy something else with somebody else. So better to bolt it all down tight and make sure you're doing all the things you need to be doing.
Yeah, and then there's still lots of variables going on, but the HOA and condo thing is something that you should be able to lock down as a matter of practice on every transaction you face. The other thing, suppose the seller loses a contract in this market. Is there a likelihood that they can go back to the other buyer? Maybe not, because there's a lot more fish in the sea. So that second buyer might have, so I'm sorry, we bought something else already. And if that other buyer is there, are they going to pay the same amount that they paid, 3 or 4 weeks ago? Maybe not. So there's quite a bit of risk here, and we spend quite a bit of time teaching the differences. However, when I see what's coming through for compliance, I don't always get a warm fuzzy that I see still a lot of HOA disclosures being uploaded for condos. And that's not going to get you out of the condo law.
And would there be, if you missed one of these responsibilities, would that be something that the consumer could bring to NABOR?
Yeah, I mean, it's Article 1 says, I'm going to deal honestly and fairly with people. I'm going to do the very best I can. I'm guessing there might be, it's not an arbitrable matter, but it would certainly be it certainly could be an ethical complaint, either that or chapter, I think it's 15, where, you're licensed to do things that you're, equipped to do and represent the customer appropriately. So yeah, I think there would be. I don't know that I've heard too much of that, but yeah, I mean, theoretically, it's a violation of the code of ethics to, miss something like this that becomes really important to the transaction. How are special assessments addressed in the contract, and whose responsibility is to pay? Okay, well, in FAR bar, it's simple. There's a checkbox. It says that the seller will pay all assessments prior to closing, or the seller will pay them up to closing. If there's installments afterwards, the buyer will pay them. In the NABOR contract, the seller's responsibility is to pay any and all assessments that are on the books prior to closing. Now, where you see this become a real issue is in many of the bundled golf communities, especially where they'll have half a dozen assessments. They'll have one for the clubhouse and one for the pickleball courts and one for the training center, another one for one of the 9s of the golf course. So you could have 5 or 6 assessments that are all spaced out and being paid monthly. And if you don't provide for that as the listing agent in negotiations, that the buyer's going to take over those assessments after closing, you could have an unhappy seller that's all of a sudden got to pay the remaining balance of all those assessments at closing in order to be able to close. They're not going to get a release from the homeowners association, the master that runs the club, unless those are paid. So you have to be very careful with special assessments. And in general, in the NABOR contract, as we say, that the seller pays anything that's on the books at the effective date. and the buyer pays everything afterwards. Where we see gray areas is when an assessment is made after the effective date of the contract. You know, in theory, any assessment that's made after the effective date of the contract, but before closing, is what we call a pending special assessment. And there's a little bit of language in the NABOR contract that says if the seller failed to disclose an obvious upcoming special assessment, meaning it was in the minutes and there was mailings sent out to the owners that there's something coming up or was coming up, then you know, you can get a little bit of relief in the NABOR contract in that the seller has to agree to pay everything over 1% of the special, 1% of the purchase price, excuse me, in terms of the special assessment, or the buyer can cancel. In FAR bar, it's a pretty simple checkbox. Either the seller pays them all or the buyer pays everything that comes up after closing. And the effective, it talks about if there's anything in the meeting minutes that would preclude, that would, you know, foresee on a special assessment, it's got to be disclosed by the seller to the buyer. And they're using the standard of the meeting minutes.
Where this slippery slope sometimes occurs is when the buyer's agent asks you, the listing agent, does the seller have any knowledge of any upcoming assessments? And maybe the seller has told you, no, I'm not aware of any. And my standard of practice is I don't get in the middle of all that. I tell the buyer's agent, have the buyer call the association directly and get it from the horse's mouth.
Right.
Because I don't want somebody coming back later and said, well, the listing agent told me this.
Yep.
And I don't want to get caught in that.
Yeah, and the fact is that many sellers are investors, especially now they're cashing out, or they occupy the residence for a couple months out of the year and family and rentals the other. They don't read the mail from the association. They don't go to the minutes, the meetings. You know, they're not really reliable sources of current information. You know, and I actually had one where there was a huge assessment coming up for redoing the balconies on a Gulf Shore property where the balconies had actually, you know, started to sag because the reinforcement bar that went into the, you know, was cantilevered, was starting to go. And it was not only leveling those balconies and reinforcing them, but also they now had to take out all of the windows and doors and replace them with hurricane grade. And that it was, I think this was like a $90,000 assessment. It was a $900,000 property. And the agent lived in the community as a renter, and the seller had been sent 8 or 9 pieces of mail, no disclosure, no nothing. So it didn't look good for either the seller or the agent after this was discovered after closing. So there you go. You have to be, I think Mark's got the right idea. You have to say, look, your responsibility is to find out if there's any of these things. We're not aware of them. The seller's not aware of them. But if there is an awareness, you know, it's your responsibility to find out if it's a pending. If it hasn't been passed at the date of the contract and it hasn't been discussed and where the seller needs to disclose it, it could be, you know, some scuttlebutt around the pool that we're going to replace the pool because it's older, but no discussion, no hard evidence. And all of a sudden you got maybe a 60-day close because of financing or whatever. All of a sudden, boom, here comes an assessment to replace the pool. It's the buyer's responsibility. There you go. But if that comes along and you're the buyer's agent and you didn't advise your buyer that something could be coming along here, you know, you're not going to look very good in the eyes of the buyer who now has to pay that assessment. What is a financing contingency and how does financing affect the proceedings of the contract? Okay, well, different contracts handle this entirely differently, but the financing contingency in the NABOR contract provides for the buyer to be able to attempt to get a loan. And if they're unable to qualify for the loan due to credit worthiness, due to the debt to income ratio, whatever, the lender can write a letter and say, hey, this buyer doesn't make it, isn't able to. The buyer gets their money back and moves on. In FAR bar, it's even a little bit more straightforward. Is usually there's a loan approval period that defaults to 30 days, and in that 30 days, the buyer is responsible to notify the seller at day 30 or earlier that they can or can't continue based on their mortgage approval. If they fail to notify them, the seller has 3 days to cancel the contract, or they move on as though the buyer is qualified and the buyer's deposits are at risk. So the two contracts work entirely differently. The one thing in the NABOR contract that's come into a play here in the last year or so, 2 years, is the waiving of the contingency. Typically in the NABOR contract, there's a period that defaults to 45 days after the date of the contract, effective date of the contract, to where the buyer is obligated to notify the seller whether or not they are going to move forward with their financing. So when we had a more balanced market for years and years, the buyer never would tell the seller that they're going to waive their contingency and put their deposit at risk. And the seller was like, geez, there's 12,000 listings in the MLS, and I got a buyer here. I'm not going to go out and cancel my contract which is my option after the expiration of the mortgage contingency period. I'm just going to hang on. Then along came a hot market, still a hot market in many neighborhoods, and the buyer decides not to waive that financing contingency. The seller does have the right to cancel. And there was some boo-hooing going on in the last couple, 12 to 18 months, because the buyer said, I'm not waiving, and the seller said, I've got another contract here, I'll see you later. The buyer lost, they got their deposit money back, but they lost the house. And of course, in a seller's market, a tight market, there might not have been any other comparable properties out there. So it was a difficult situation. So that financing contingency waiver is now going to come back into more of a gray area as we get more listings and as the supply side goes up. That many financial advisors were advising their customers not to waive the contingency, because you could lose your job or something could happen health-wise to you between now and the closing, and your deposit would be firm. And there was enough supply in the market, enough play in the market, that the sellers weren't anxious to cancel. But still, we only have a couple months, 2.5 months of inventory, and that means there may not be a lot of options in a specific neighborhood or for a specific type of property for a buyer. So I think you have to be careful to ask them to study this waiver with their financial advisor and their lender to make sure they don't lose the property unnecessarily. Anybody want to add to that? Mark, what do you think about when buyers say to you, should I waive my financing contingency?
Yeah, I think it goes back to the individual circumstances. How are they moving here because they're getting a job, or is this a second home or an investment property? How many homes did they look at before they found the one that they wanted? What's the likelihood that something else is going to come on the market that's going to fit all their needs the way this one does? So I don't know that there's a black and a white as far as a clear-cut answer one way or the other.
I agree with you. It's an individual circumstance, and you as the trusted agent surely wants to have them consult with their lender, their financial advisor. You may want to do a little market review to say what would happen if we lost this home, and try to give the buyer as much information as possible. But in general, I still think the supply is so tight, and finding a specific home with specific requirements, it may be much tougher if a buyer loses the home because the seller goes back on the market or has a backup offer that they're going to take.
And I guess, as in all things, document in an email the conversation that you had with the parties, so that someone doesn't come back and say, you never told me, or you
Yeah.
told me something different.
Yeah, agreed, because it can be a deal breaker. And, even the mortgage contingency waiver says that I have consulted with my financial advisor or my mortgage lender before making this decision, because it does make your deposits firm there. So, all righty. Well, we got a couple more questions that we can throw into next week's discussion, but 2:57 will end on time here. And Mark, I always appreciate your jumping in and giving us your insight, because you're out there where
Hey,
all the action is.
it reminds me of things that I need to do and things that I need to brush up on and look at things maybe from a different point of view.
Kristen, thanks for hanging in there with us. Hopefully we made your hour worth, or your hour and a half worthwhile there.
Always. And again, I also would like to thank you, Mark. Your insight is very helpful.
Beautiful. Okay, well, everybody have a great rest of your Monday, and we'll see you next week. I'll have the market data we can go over and see what's happening and see if anything's different. Take care.
All right. Thanks, guys.